I'm Hope Fry. I'm the Executive Director of Project Lifeline and an immigration lawyer for 40 years. On September 7th, the government published proposed regulations which would dramatically change the rules governing the detention, release, and treatment of children held by immigration. This is the last installment of a 5-part series discussing this proposal. Although each segment is freestanding, watching them in order will increase your understanding of the proposed regulations. The first installment creates a context for understanding the impact of the rules. We look at the fast-track deportation procedure called expedited removal, which is the procedure used for undocumented parents with children coming across the southern border. It does not apply to children who come unaccompanied. This is a highly adversarial process during which the individual has few rights. The second installment examines the history of the Flores settlement, an agreement between the government and Flores Council that sets the nationwide standard for the detention, release, and treatment of all children in immigration custody. I'm going to call that agreement simply Flores. Flores is important since any regulations issued by the government are required to be consistent with Flores. Parts 3 and 4 discuss 2 aspects of the proposed regulations which would supersede and eliminate Flores and the protections it provides children. This segment explains the rulemaking process and begins the discussion of what you can do to tell the government what you think of their proposed regulations. Our final segment will talk in detail about commenting on this rule with suggestions for how you can write your own. We will also roll out information on our website, projectlifeline.us. Our website will have draft comments which you can use in whole or as a model for writing your own. We'll post directions for submitting your comment. There are special directions issued by the government for doing that. Or if you'd like to sign on to Project Lifeline's comment, there will be a place for you to sign up to do that. Comments are due not later than November 7th. We are submitting ours on Election Day. Agencies get their authority to issue regulations from the statute enacted by Congress. An agency must not take action that goes beyond its statutory authority or violates the Constitution. Agencies must follow an open public process when they issue regulations, which is called informal or notice and comment rulemaking. A proposed regulation is the official document that announces and explains the agency's plan to address a problem or to accomplish a goal. The proposal we are concerned with here is titled Apprehension, Processing, Care, and Custody of Alien Minors and Unaccompanied Children. That's the statement of the problem. All proposed rules must be published in the Federal Register to notify the public and to give them an opportunity to submit comments. The proposed rule and the public comments form the basis of the final rule. Once a rule goes final, it has the full force of law. Proposed rules have a preamble, which contains useful information and a discussion of what the agency proposed, including its choices and reasoning in detail. The preamble is very important. The full text of the regulations follows the preamble. Anyone can submit a comment on all or part of the proposed rule. An agency is not permitted to base its final rule on the number of comments in support of a rule over those in opposition to it, or vice versa. In issuing a final rule, the agency must base its reasonings on conclusions on the rulemaking record, consisting of the comments, data, expert opinions, and facts accumulated during the pre- and post-rule stages. The record, called a docket, is available online for public view, which means who you are and what you say is there for everyone to see. You can submit your comments electronically through the federal portal, e-rulemaking portal, by email or by mail. You can look at the docket anytime to be sure your comment was received. A comment can challenge a number of things: the factual assumptions, application of data and research analysis, financial projections, and policy conclusions. A comment must clearly explain your views and your reasoning. To be effective, each issue you address should be tied to specific portions of the regulation. A meaningful comment is supposed to get meaningful consideration. Here's an example of how you might comment. The portion of the proposed rule I'm going to talk about was discussed in segment 3 of this series. Let's say you want to comment on creating two groups of children who are then treated differently with respect to release, those children who come with family and those who come unaccompanied. If in your comment you could point out that the regulation must be consistent with Flores and that the Ninth Circuit Court of Appeals has held that all children are covered by Flores whether they are with family or not, that court rejected the very thing that the rules now propose. You might conclude your comment by suggesting that the rule attempts to make legal that which has been clearly by the courts found illegal. After the comment period closes, the agency reviews and conducts an analysis. Then they decide whether to proceed with the rulemaking process or issue a new rule or a modified proposal. Sometimes the proposal is withdrawn completely. The final rule has a preamble, and it's there that the agency details and responds to the significant and relative issues raised by the public. The final rule is published in the Federal Register. Comments are due 60 days after the rule is issued. This comment is due on November the 7th. We urge you to comment. Join us, write one on your own, or join the many groups that are commenting.